All right, so in this video, we're going to be looking at the Associated Newspapers and Bancks case. This case was to do with a cartoonist. And in fact, it's the cartoonist of Us Fellas, which is the cartoon that their famous character Ginger Meggs came from. So I have some Ginger Meggs pictures for us today on the slides. Very on theme. All right, so in this case, Bancks, who's a cartoonist, entered into a 10-year contract to supply his cartoon Us Fellas to Associated Newspapers. A key term of the contract was that the cartoons would be published on the front page of the lift-out cartoon section. Now, there was a shortage of newsprint, which meant that the newspapers changed the format for 3 weeks running. And because of that, the cartoon was printed on page 3, not page 1 as required under the contract. So the key question before the court became whether the term that the cartoon be printed on page 1 was a condition of the contract or merely a warranty. And if it's a warranty, then Bancks would have the right to damages. But if it's a condition, Bancks would have the right to terminate the contract in addition to damages. All right. So here, the High Court endorsed the approach in Tramways that determining whether a term is a condition depends on its essentiality to the contract, which is primarily a case of asking, would the innocent party have entered into the contract without assurance of a strict and literal performance of the promise? So would Bancks have entered into the contract if he had known that there was a possibility that the cartoon wouldn't be featured on page 1 of the lift-out section? Okay. Now here it was ultimately held by the High Court unanimously that there was a breach of a condition, so that term was an essential term of the contract, the location of where the cartoon would be printed. And as we'll see in the case reading guide, this came down to the fact that the obligation to supply the comic and the obligation to print it on the front page were concurrent and correlative promises. So both were equally important. Okay, so both were essential terms. Okay, so let's have a look. All right, so in terms of our case reading guide questions then, who is suing what for? No, who is suing whom for what? I can totally read today. All right. So originally Bancks was suing Associated Newspapers and won, and then the High Court case was actually an appeal by Associated Newspapers from the decision of the New South Wales Supreme Court. And then Associated Newspapers was seeking an injunction to restrain breaches of negative covenants. So presumably they were trying to seek to stop Bancks publishing the cartoons elsewhere. So they wanted the contract to be on foot so they could restrain him from going elsewhere. So it's not so much about getting him to continue to supply them, it's about making sure the cartoon isn't published by someone else. Okay. Now, how was the issue of breach relevant then? If Associated Newspapers had breached an essential term, then Bancks is entitled to accept the breach as a repudiation of the contract and to terminate the contract. Okay. So if it's an essential term, he has the right to terminate. And then if he has the right to terminate, he is not bound by those restrictive covenants that stop him from going elsewhere. Okay, so what promise did Associated Newspapers breach? This is quite straightforward. As mentioned, it was just that the cartoon was supposed to go on the front page of the comic section, and for 3 weeks in a row it was printed on page 3 rather than page 1. So the third question, then how many times, as a follow-up from that question, how many times did they breach? How did the number compare with the number of occasions they kept their promise? So they breached 3 times on the 11th, 18th and 25th of February. The 4th of March, he was back on page 1, his Ginger Meggs cartoon. So the issue here was whether this was this amounted to a substantial performance of obligations under the contract. So it was potentially argued to be a repudiation issue. So whether those 3 breaches went substantial performance, but you'll note here that the court saw it as a condition and warranties issue rather than a repudiation issue. So that, yeah, we'll just leave that there. Okay. So for them, it was essential whether it was a term or condition, essential term, a condition or a warranty, not as to whether the nature of those breaches of a warranty amounted to showing an unwillingness to perform. Because, yeah, okay, so it's only if it had been a warranty that the repudiation issue would have been live. So in terms of the next question then, on what question did the court say Banks's right to terminate turned? So the court saw this as whether the undertaking to present the drawings on the front page of the comic was a condition or essential term of the contract, or alternatively, whether it was a mere warranty. Now, what is the test of essentiality, and what facts in this case indicate that the promise to publish on the front page of the comics section was essential? So the test of essentiality is the test to determine whether a term is a condition or just a warranty. The test itself is whether it appears from the general nature of the contract considered as a whole, or from some particular term or terms, that the promise is of such importance to the promisee that they would not have entered into the contract unless they'd been assured of a strict or substantial performance of the promise, and that this ought to have been apparent to the promisor. Okay, so essentially this means that if the party, the innocent party, so if Banks here had not entered into the contract unless assured of a strict and literal performance of the promise, then they will, then that term will be seen to be essential, and he then has the right to terminate. Okay, so it doesn't really matter how that essential term is breached or how flagrant it was, how many times. The simple fact of the breach of the essential term, the breach of the condition, will give rise to that right to terminate. And as well, the court made it very clear that this is an objective test. Okay, so it's not about what Banks subjectively thought, it's about what someone in his position, from the outside, looking at the actions, whether they would have entered into the contract, knowing that strict and literal performance was not necessarily, if strict and literal performance had not been required. Okay, now, it's kind of central. So the courts obviously ultimately held that this term was essential to the contract. And part of their findings around this was informed by the fact that Banks was not an employee but a comic artist. So he wanted his work published in the most conspicuous place of the comic section. So the placement was incredibly important to him, given that he's an artist and given that the exposure is important. So yeah, so when applying that test objectively, the nature of his profession as a comic artist was taken into account. There's that essentiality test. So in terms of the next question, which should be question 5, not question 6, my numbers are all out of order. What independent ground did the court give for justifying Banks's right to terminate the contract? So after the breach and complaint by Banks, the executives claimed that anything done by way of change would be done as a matter of grace, not right. That constituted a repudiation of the contract on the part of the company. All right, we'll leave that there. Okay, Banks and the Associated Newspaper case.